abandoned its claim against Azumah Ghana, a development widely reported in the Ghanaian media as paving the way for Azumah Ghana to commence development of the Wa and Black Volta project unimpeded. The Honorable Minister for Lands and Natural Resources, Emmanuel Amakufibua, was internationally praised for resolving the Azumah EMP dispute and assuring investors at the Africa Down Under Conference in Australia that Ghana remains a model of stability. Yet within days, EMP has defied that resolution by forcibly seizing the mine without legal basis, directly undermining the minister's own words and casting significant doubt on Ghana's ability to guarantee the rule of law. If such a transfer had occurred, it would amount to an expropriation of private property. This would expose the government of Ghana to claims exceeding $1 billion under both Ghanaian law and international treaties. It would also fundamentally undermine the message delivered by the Honorable Minister at Africa Down Under last week. Azumah Ghana intends to apply immediately to the International Court of Arbitration to prevent any such unlawful seizure by EMP and to ensure that the rights of its shareholders and the interests of the people of Ghana are fully protected. There are two more paragraphs to conclude this statement.
Yes, Samson, good morning. Good morning to the viewers. Like you said, 2 months ago, you were expecting me to be here when this started, but I had to pull out at the last minute. I apologize to you. And I want to say this, that
the minister had issued a statement.
Yes.
Called all of you to order.
Yes. The challenge.
And called you to a negotiation that he will mediate.
Yes.
Or the minister will mediate through a committee.
Yes.
And ask all of you to cease fire.
Yes.
All right.
Now, the challenge that I have, and I would say EMP has, is that, you see, the media publications or discussions are not being done by the disputant parties. In the sense that Mr. Simmons had made reference to Iberia, to Kangol, to Egik. You do not have anybody sitting here saying that I'm from Iberia, I'm from Kangol, I'm from Egik. Mr. Simmons obviously gets his information from whatever sources he's getting. He is, for lack of a better word, lawyers will say, relaying hearsay information, what somebody has told him. Now, EMP, and to an extent myself, because I was involved from day one, the negotiation of this before the contract was signed. So I didn't just come in. In 2022, when the original owners approached EMP before negotiations dovetailed into 2023 before agreement, I was part from day one. So I know this not because somebody has told me or a client has asked me to come and say it, because I was part of the negotiations.
So we also get information, we get documents, we verify.
Yes, that's what I'm saying. When you have documents, he said that they have asked the international lawyers to interpret the document for them, and based on the interpretation.
Says so because he's not a lawyer.
That is what I'm coming to. I feel challenged, because what it will mean is that you are literally asking me to have an analysis of a legal document with a non-lawyer. Now, I would, and I had made this point earlier.
He's been advised.
What is the weight of that advice when it cannot be relied on?
When you advise your clients, you're supposed to use your advice.
No, but that is what I'm saying. He's not a client.
That doesn't make...
He's not a party.
I'm saying when you advise your clients, normally, you expect them to use the advice.
Oh, yes, yes.
And that doesn't make the advice less potent.
But that is what I'm saying.
Because it's not being communicated by a lawyer.
That is what I'm saying. No. What I'm saying is that I am not the client. I am the lawyer.
Okay.
So if I ask legal questions, he will not be able to answer.
All right.
Now, the point that I want to make is that there are two matters that I really want to respond to this morning, if you could permit me. The first one is the consistent allegation of me personally having been engaged in some form of conflict of interest. I remember on your show, he kept using the word, my good friend Bobby Banson, our good friend, has been paid a certain amount, I think 500,000.
You mean the previous edition?
Yeah, the previous show, which he has consistently repeated. Now, because as a professional, we are guided by a code of ethics that that regulates what we do, how we do it, how we say it. You've known me since 2005, not today. This measure acquisition involving, it's not the first one that I have done to this volume. It's not. And hopefully by the grace of God, it will not be the last. So I would want on this platform an opportunity to explain that, Mr. Simmons, I have not pocketed 500,000 as you were told. You were giving bank
you're a lawyer. If you work and you get paid,
no, he didn't say that it was my payment.
Okay, go ahead.
If he said it was my payment, it's different.
He was giving bank statements.
He had said that I have been unlawfully paid $500,000 from an account without the knowledge of the owners of that account, and I have used that money to pursue arbitration. And he had said that that constitutes conflict of interest. And he had repeated it on his social media handles. Now, it is never true. One, something. You, as a lawyer, know in transactions, there are instances where the client's holding accounts, which the ethics of our legal profession allows us to open for certain transactions, will be allowed to hold money in the form of an escrow. As soon as whatever conditions are met, those monies are transferred to whoever is supposed to receive. Now, this $500,000, now because of client privileged information, was not transferred to me as fees. It has never been kept by me. When this $500,000 was paid into our client holding account, it was for a specific purpose, that the signatories to that account, which are board members of Azumah, wanted the money paid into my account until the issues surrounding the signatories to that account are resolved. So in effect, I was just holding it. As soon as the signatories to that account was resolved by virtue of the court order or the court processes in Ghana, all of the $500,000, not even one CD, was transferred back into the Azumah account. Not even, and this was as far back as November 18, 2024. So for it to be repeated now, as if that money is still sitting in my account, or I'm using that money for any collateral purpose, was most unfortunate. And I'm using the word unfortunate because if indeed Mr. Simmons and his team said they don't have any interest in this matter, they wanted to verify, they could have easily written to say that we are going to town with an allegation that you have received $500,000, which you are using for purpose or without the knowledge of the owner. What is your response to it? Then we can say that, okay, they reached out and I chose not to respond, or they reached, because this does not involve EMP. The allegations that he made concerning the $500,000 was against myself. It had nothing to do with EMP.
Which is the next issue, so that he can respond quickly.
Yes.
Then you go to the question.